unfortunately, I think what the evidence now shows is that rather than being truly independent, that too many lawyers at OLC during particularly the Gonzalez administration provided not independent evidence, but instead provided backup or legal cover for very dubious steps that the administration either had already taken with regard to interrogation or were planning on taking in the future. The one memorandum that I want to focus on particularly here today is the August 1st, 2002 memorandum that was written for Alberto Gonzalez and signed by Jay Bybee. Now, it has become clear that Jay Bybee was not the primary author of that memo. Instead, the primary author of that memo was John Yoo, who now, as you know, is here at Chapman on a visiting professorship. And as some of you may know, myself and Professor Larry Rosenthal will be debating Professor Yoo and Dean Eastman on April 21st, next Tuesday. And that event has generated a lot of interest on campus. And the memoranda will be one of the topics that will be discussed. The memorandum that was drafted or produced on August 1st, 2002, and the book that Shirley mentioned that I co-edited in 2003, which is called Civil Liberties versus National Security in a Post-9/11 World, contains excerpts of that memo. When this book was going to press, that memorandum had just been leaked to the press, and so we were able to get copies very quickly and include it in the book, even though we were just about to go to press with the book. And I think it's an important background memorandum. It's called a variety of things. Some people just refer to it as the torture memo. Other people refer to it as the Yoo memo, or confusingly as the Bybee memo, because I think the authorship has been somewhat unclear. But in an upcoming article that I plan to publish in the next few months, I suggest that we refer to that memo as the Bybee-Yoo Torture and Power Memorandum, or BITAP. So I will refer to it from now on as the BITAP memo. And why do I say I think we should refer to it as the Bybee-Yoo Torture and Power Memorandum? Well, first of all, I think it's important that we hold responsible both the signatory of the memorandum, Jay Bybee, who is now a federal Court of Appeals judge in the Ninth Circuit, as well as Professor Yoo. And I wanted to say here, somewhat as a side note, that I have found it very disturbing that there has been so much outcry regarding Professor Yoo, and yet not nearly so much regarding the role of someone who is now a sitting Court of Appeals judge, Jay Bybee. And indeed, in the most recent memos that were produced by the Obama administration just this week, the ones that were declassified, again, it is Jay Bybee who wrote the famous insect memorandum, which talks about the fact that it would be okay to put an insect in a small box with a man known to have an absolute terror of insects. This sounds to me like Orwell's 1984, not a progressive democracy in the 21st century. And yet, strangely enough, Jay Bybee has received a virtual pass with regard to his role in these memoranda. Now, of course, his role was not known at the time he was confirmed. But at this point, while we're all talking about what should happen to John Yoo, I would suggest that calling for the resignation of Judge Bybee would be an appropriate step. Because, quite frankly, someone who wrote the kinds of memos or signed them, even if he didn't write them, he read them, he reviewed them, it was his job to sign them as a lawyer. He does not have the type of judgment that we should expect for people sitting in the Court of Appeals deciding life or death matters with regard to issues in the United States. So I want to initially say that I think the role of Jay Bybee is just as critical and something we need to be just as focused on as the role of Professor Yoo. So that's my talk about the role of Bybee and why I would never like to delist his name when we discuss these issues. So I always say it's the Bybee-Yoo Torture and Power Memorandum. Now, I want to go to the definition of torture that is contained in the United States Code, and I'm sure many of you are familiar with this. Torture means an act committed by a person acting under the color of law, specifically intended to inflict severe physical, mental pain or suffering. So physical or mental pain or suffering is absolutely forbidden by statute within the United States Code. And so that was the starting point for the memorandum that was generated Judge Bybee and Professor Yoo. And famously, and I'm sure most of you are very familiar with this, in that August 1, 2002 BITAP memo, they concluded, basically, that in order to rise to the level of torture, you would have to inflict pain on a person as follows. The level that would ordinarily be associated with a sufficiently serious physical condition or injury, such as death, organ failure, or serious impairment of bodily functions. So this was, in my view, a significant narrowing of the definition so that virtually anything, such as waterboarding, would be permissible. Now, quite frankly, I think waterboarding is so significantly painful that it should fall even into their definition. But it's pretty clear now that we look at the evidence that what was going on in the Office of Legal Counsel is that they were trying to justify waterboarding, which as of this point had either already occurred or was about to occur. And so they were trying to narrow the torture definition to exclude something like waterboarding. So that's why I refer to it as the Bybee-Yoo torture memorandum. But there is a second feature of BITAP that, in my view, is just as destructive. And that is the claim. I mean, first they're narrowing torture to be such a narrow standard that you can get by with things like throwing people against a wall, waterboarding the person, making them stand in stress positions. That's bad enough because you've basically taken a very clear prohibition on torture and tried to muddy the waters by saying, well, as long as you're not going to result in organ failure, it's okay. But beyond that, they go on to claim that in order to respect the president's, and this I'm quoting, inherent constitutional authority to manage a military campaign against al-Qaeda and its allies, Section 23040A, which is the torture prohibition, must be construed as not applying to interrogations undertaken pursuant to the commander-in-chief authority. So even under their narrow definition, which allows for almost everything, they're saying even that doesn't apply to the commander-in-chief as long as he invokes his authority. So in other words, what they're saying in BITAP is torture is just this very narrow thing that you can't do. But even if you do something that results in organ failure or death, as long as you're the President of the United States and you say, I'm the Commander-in-Chief, you can do whatever you want. There are no limits. So this power grab, this claim to be beyond the law, this claim in contravention of the constitutional requirement that the President shall faithfully execute the law is, in my view, even more devastating to our constitutional system than perhaps the narrow definition of torture. So that rounds out my description of the BITAP memo, the Bybee-Yoo torture and power memo. Because even under their narrow definition of torture, they're saying our president doesn't have to follow that definition. And I think that's absolutely devastating. Now, I have very little time, but I want to make just a couple more points in this regard. And that is an accusation that I think many of us on the progressive side of the political spectrum hear all the time. And that is, well, this is just ideological. You're just going after people whose politics you don't like. I think it's absolutely critical for people to recognize that even within the Bush administration, even some of the most conservative Republicans working in that administration recognized that BITAP was out of bounds. And it was the Bush administration itself